My name is Heather Seubert. Spelling of my last name is Seubert.
Good morning, Ms. Seubert.
Good morning, sir.
Can you tell us what is your occupation?
I am currently the unit chief of the Firearms Tool Marks Unit at the FBI Laboratory located in Quantico, Virginia.
Okay. And in 2008, what position did you hold with the FBI?
In 2008, I was one of the supervisory forensic DNA examiners in the DNA analysis unit, also at the FBI Laboratory.
Okay. And how is the DNA analysis unit broken down at the FBI Laboratory?
Well, currently there are actually three DNA units. There is the mitochondrial DNA unit, the nuclear DNA unit, and the federal DNA database unit.
Okay. And could you give the ladies and gentlemen of the jury just a brief synopsis of what each unit does?
Sure. In the mitochondrial DNA analysis unit, that unit's responsible for examining items of evidence for mitochondrial DNA typing. And the types of evidence that they receive are typically samples, bone, hairs, and teeth. In the nuclear DNA unit, the unit's responsible for also examining items of evidence for the presence of biological fluids such as blood and semen, and then examining those stains for processing them for DNA typing. And then in the federal DNA database unit, that unit does not receive any items of evidence. Its mission is to process samples from known convicted offenders for entry into the National DNA Index.
Okay. And how long have you been employed with the FBI?
Just about 12 and a half years. I started in October of 1998.
And with whom were you employed before the FBI?
I was employed with the Department of the Michigan State Police as a forensic scientist in the forensic laboratory located in Lansing, Michigan.
And what is your educational background?
I've received a Bachelor's of Science in Forensic Science from Michigan State University located in East Lansing, Michigan.
And have you taken any additional coursework in the area of DNA analysis?
Yes, I have. I'm actually currently enrolled in the graduate program at the University of Florida out of Gainesville, Florida, in a master's program focused on forensic DNA and serology. And I've also taken coursework through the George Mason University, which is located in Fairfax, Virginia, in the areas of statistics and genetics. And I've also taken a molecular biology course from Lansing Community College, located in Lansing, Michigan.
And have you taken any specialized training while employed with the FBI?
Yes, I have. I actually started as a biologist in the mitochondrial DNA analysis unit when I started with the Bureau in 1998. And so I was trained and qualified as a biologist, so I had undergone a specialized training program to perform DNA typing on bones, hairs, and teeth. And then I was promoted to a forensic DNA examiner in 2001. And as a part of that program, or that position, I was trained and qualified under the supervision of a qualified DNA examiner to perform those job duties. And then I had also spent time in the federal DNA database unit, so I underwent a truncated training program to be a qualified database examiner as well.
And could you tell the ladies and gentlemen of the jury what is serology?
Sure. Serology is the science involved in identifying biological fluids such as blood, semen, and other biological fluids.
Okay. And have you received any training in serology?
Yes, I have. When I started with the Michigan State Police, I was devoted most of my time as a serologist in that position, and so I was trained and qualified as a serologist to examine items of evidence for blood and semen. And then when I started in the DNA analysis unit as an examiner, I also, as a part of my training, underwent some serology training there as well.
And have you done any teaching or public speaking in the area in the fields of forensic science?
I have. Is one of my job duties with the FBI was one of the primary instructors on the FBI's quality assurance standards. And so I did that for a number of years and probably provided instruction to well over 1,000 DNA analysts on what are termed as the quality assurance standards, which laboratories performing DNA typing and entering DNA profiles into the National DNA Index have to comply with. And so I provided instruction on that for a number of years. And I've also presented at conferences on the area or in the area of the quality assurance standards and provided also specialized topics in DNA at conferences as well.
And are you a member of any professional organizations of forensic science?
I'm a fellow of the American Academy of Forensic Sciences. I am currently one of the proficiency test review members for the biology section for the American Society of Crime Laboratory Directors Laboratory Accreditation Board. And I was the vice chair of the scientific working group on DNA analysis methods, but I retired from that position in January of this year.
What does that mean, the scientific working group for DNA?
Well, the Scientific Working Group on DNA Analysis is a group of individuals from many different forensic laboratories across the United States and also internationally that are devoted to discussing current topics in DNA and setting guidelines, as well as managing the quality assurance standards for forensic DNA testing laboratories and DNA database laboratories. And they meet twice a year, and they're responsible for issuing documents for forensic laboratories and database laboratories to use in their analysis.
Okay. And have you testified as an expert witness in serology and DNA in the past?
Yes, I have.
Where and how many times?
Since I've been with the FBI, I've provided testimony 18 times and have been qualified as an expert 18 times in the area of DNA and serology, and the federal court systems that I've been qualified in have been Washington, D.C., Albuquerque, New Mexico, Oklahoma, Kentucky, Louisiana, Michigan.
Would that be all across the country?
Yes, sir.
Okay.
Sorry.
All right. Your Honor, at this time, I would move Ms. Seubert to have her admitted as an expert in serology and DNA analysis.
The state absolutely agrees, Your Honor.
Ladies and gentlemen of the jury, the witness will be accepted as an expert witness in the area of DNA analysis and serology. You may proceed.
Thank you, sir. Now, Ms. Seubert, how were you initially involved in this case?
When I was working as a forensic DNA examiner in the DNA analysis unit, I was the individual assigned to this case when it was received at the FBI laboratory.
Okay. And did you issue a report on October 8th of 2008?
Yes, I did. And at this time, if it would be acceptable that I may refer to the notes that I brought with me today that I used in conducting my analyses.
You may.
Thank you, sir. I have the October 8th, 2008 report in front of me, sir.
Okay. Now, I'd like to take you section by section, if we can do that.
Okay.
To the relevant sections. Can you first tell the ladies and gentlemen of the jury what Q's and K's mean?
Sure. At the FBI laboratory, there is a process of assigning a Q letter or a K letter to items of evidence when they're submitted to the laboratory. And this helps to distinguish the location or where the item was collected from. So a Q specimen would be a specimen that was collected from a crime scene. It is something that's not known to a person. A known or a K sample would be a known blood sample, a known hair sample, and things that can be associated directly to an individual.
So if you took my DNA with a buccal swab, I would be K1 or K2 or K3, however number of items.
That's correct.
Okay. And if you collected an item off of the floor, that would be Q1, Q2, and so on.
Well, that would depend.
Okay.
Okay. If you were taking a known fiber sample from this floor, that would be considered a known representative sample, and that would be a K. But let's say hypothetically, if you had dropped a mask or a hat, and that was collected off of this floor, that would be a Q specimen.
Okay. Thanks for clearing that up. Now, were you given items having to deal with the car of a Pontiac Sunfire that belonged to Miss Caylee Anthony?
Yes, sir.
Okay. What were you given exactly? And we'll start with, if we can, the first items on your report.
The items of evidence that were received at the laboratory were received into the lab under a cover of communication dated July 28, 2008. And simply a cover of communication just refers to an incoming letter which describes the facts of the case to the laboratory for processing.
You know, I do have an objection that I might raise at the record to whether the items are in evidence, but perhaps counsel can clarify where we're going with this. And
I'm questioning the witness what work she's done on this case.
right, but to testify about matters that are not in evidence, obviously that's a predicate, and I thought if counsel could clarify for us, maybe we wouldn't have a problem with it.
Okay.
These are items that are in evidence.
If I could just ask
Well,
counsel.
let's approach the side, our folks. Okay, ladies and gentlemen of the jury, there are going to be some matters we're going to need to take up outside of your presence. We're going to recess to 10 minutes past the hour of 10. I'm going to ask you not to discuss this case among yourselves. This would probably be a good time to take a special break. Any additional instructions on behalf of the state or the defense? No, sir. Okay, we'll be in recess. State recognized persons of jury.
Yes, sir.
Defense,
Yes, sir, we do.
you may continue.
Thank you. Ms. Seubert, we left off talking about some items that you were given to test, and I'd like to take you through those items. First, I'll refer to Q from your report, Q13 and 14, which has been identified as State's Exhibit IJ. Can you look at that item, can you look at your notes and tell the ladies and gentlemen of the jury what you did?
Yes. The two items, Q13 and Q14, and I apologize, I didn't hear the state's exhibit number, IJ, were identified as swabs from spare tire cover collected from the vehicle, tag number G63XV.
If I may, I'm sorry. I think that those probably need to be formally moved into evidence by the defense, to which I have no objection before the witness testifies about the analysis.
Okay.
At this time, we move item IJ into evidence.
There being no objections lodged by the state of Florida. Huh? No, these are me. You wanted, it was marked for ID by whom?
By the state, but we'll move it into evidence. That's fine.
That would be a defense exhibit.
Right, be defensive, but they're moving it.
Yes, sir.
Yeah.
Thank you, sir. Okay. When you have Defense Exhibit 13, when you have that, what's the first thing you did with those items?
So each of those items were looked at independently. So the first item, the Q13 swab from the spare tire cover, was examined in the laboratory, and a chemical test was actually performed on a portion of that swab.
Let me stop you there if I can. Okay. When you inspected, you're in a laboratory, correct?
It is performed in a laboratory setting, performed by a biologist of the DNA analysis unit.
Okay. And what is the first thing done? The test that you're referring to, the phenolphthalein test, correct?
Correct. It's a chemical test, which is a test that will detect the possible presence of blood. And it is the official name it is called by is the phenolphthalein test, correct?
Okay. And what were the results of that test?
On each of those swabs, The test for the presence of blood was negative.
Now, I'd like to take you and direct your attention to the second page of your report on items Q22, which has been entered into evidence as states 143.
On those items, Q23, which was identified as a piece of spare tire cover, a chemical test was also performed on that item for the presence of blood, and it was negative.
Okay. And then after that, with that item, what did you do?
Well, after that item, the testing was conducted on that item. It would have been repackaged up, and then the next item would have been opened up and also tested as well, and that item would have been Q23.
And that is, for the record, states evidence 139. And what did you do with that item?
And that item was identified as a spare tire cover, and on that particular item, there were brown and yellowish stains that were observed, and those stains would have been tested using a cotton tip swab from the laboratory. So distilled water was placed on that swab, and those areas were actually then individually swabbed, and then the chemical test was performed on each of those swabs from each of those stains that were observed, and those were all negative for the presence of blood.
Okay. Now, when we are talking about spare tire cover, that's a round circle cardboard type carpet material?
Correct. A particle board type backing, correct.
Okay. And then can you tell the ladies and gentlemen of the jury what the next item is?
The next item that was examined was Q24, and that was identified as the left side of trunk liner.
Okay.
It was,
Just for the record, that's states evidence 139. First, describe the item to the ladies and gentlemen of the jury so they kind of have an idea of what you're talking about.
States Exhibit 139, or my item number Q24, was a dark gray carpeted section with a multicolored fabric backing on it. And then on that item, again, brown and yellow areas were looked at throughout, and those areas were swabbed and tested for the presence of blood, and they were negative.
Okay. And then what's the next item?
Q25.
And what is that described in your report as?
Q25 is the right side of the trunk liner.
Okay, and that, for the record, is state's evidence 140. Tell the ladies and gentlemen of the jury what you did there.
On that item, it was another section of a dark gray carpeted section with the multicolored backing, and brown and yellow areas were identified throughout as possible stains. And a cotton tip swab was taken, water was applied, and those brown and yellow stains throughout were swabbed, and then the chemical test was performed on it for detecting whether or not blood was there. And all of those stains were negative for the presence of blood.
Okay. So you had the spare tire well, correct?
Yes, sir.
The left side of the trunk liner and the right side of the trunk liner.
Yes, sir.
And you tested all of those areas for blood.
Objection, asked and answered.
Overruled.
Yes, sir. All of those all of those items were tested and were negative.
Okay. What did you do with the swabs that you took from those items after you tested the area for blood?
Well, after a swab is taken and the chemical test is performed on that swab is not retained by the laboratory. The chemical test has been performed. The period to see if a color change is going to take place or not has been observed, and that swab is not retained.
Okay. Did you do any other tests on those items?
Yes, sir.
Okay. Can you tell the ladies and gentlemen of the jury what kind of tests you did after that?
Yes, on those particular items, again, I'm referring to my notes.
Sure.
On specimen Q22, which was the piece of the spare tire cover, Q23, the spare tire cover, Q24, the left side of the trunk liner, Q25, the right side of the trunk liner. A swab was taken of those items and processed for DNA typing.
Okay. And what were the results of the DNA typing for the trunk of the car items that you described?
There was no DNA profile generated from those items.
Okay. Now, just so the ladies and gentlemen of the jury can understand a little bit about a little more about what you do, the phenolphthalein test the chemical test that you did, that was for blood, correct?
That's correct.
Is it fair to say that the reason you took it a step further was because there are more types of bodily fluids that you could pick up for DNA that you can't from that chemical test?
Objection leading.
Sustain, rephrase the question.
Why
Why did you do the DNA test?
Well, although the chemical test for the presence of blood was negative, the next step was to determine were there any other type of biological cellular material that could be detected through swabbing and a DNA result generated from that. So from any cellular material that could be present, or if there were any other types of stains that were there that weren't necessarily observed that could have contained DNA material.
And what can you get DNA from in a person's body?
Well, DNA is contained within every cell of your body except your red blood cells. They don't contain a nucleus. So any type of cell that has a nucleus is where the DNA is housed. So skin cells, white blood cells, the tissue, if you yank out a piece of hair, the tissue that's contained in there. And all of those cells within the nucleus contain the DNA. And that DNA is the same in all of your cells.
Okay. All right. Now, further down on page 2 of your report, you received. Can you describe to the ladies and gentlemen of the jury what the items are from Q33 to Q43? And just for the court, the state and the defense have a stipulation with no objection on these description of these items.
If counsel could just remind me which item those are?
The clothing.
The clothing. No objection.
Okay.
I believe the agreement is that those are the items referred to by Investigator Boise as being clothing from the Anthony home.
Thank you, gentlemen.
Thank you. You received some items from closet of East Room at 4937 Hope Spring Drive, correct?
That's correct.
Okay. Can you tell the ladies and gentlemen of the jury what you did with Q33 and so on?
Yes, so the items that were submitted from the closet, there were several different particular items, and I'll start with the first one, which was Q33, which was identified as a pair of pants. They were dark gray color, and that item was visually examined for the presence of any biological stains, and none were observed. So in that case, on that particular item, there was no chemical testing performed.
Okay. And what about Q34?
Q34 was identified also as a pair of pants, and they were actually light blue pants in color, and that item had some faint brown, yellowish brown spots contained on those pants, which were tested for the presence of blood and tested negative for the presence of blood.
Okay. And Q35?
Q35 was identified as a pair of pants. They were a pair of blue jeans, and a visual examination was performed on that item, and no biological stains were observed, and therefore no chemical testing was performed on that item.
Okay. Q36?
Q36 was identified as a skirt. It was a light gray skirt and had some very faint yellow type stains contained on that skirt, which were tested for the presence of blood and tested negative.
And Q37?
Q37 was identified as a skirt, and it was a light yellow skirt, and there were faint red spots throughout, primarily on the outside, the front left, and those were negative for the presence of blood.
And Q38?
Q38 was identified as a skirt. It was a light beige skirt, and had faint yellow areas contained on it, and those areas were tested and were negative for the presence of blood.
Q40? I'm sorry, did I skip 39?
Correct. There's Q39. Q39 was identified as a shirt. It was a light blue button-down long sleeve collared shirt, and it had some faint discolorations contained on the left breast pocket, and those areas were tested and were negative for the presence of blood.
And Q40?
Q40 was identified as a shirt. It was a light beige button-down three-quarter sleeve collared shirt, and there were some faint areas of discoloration on the outside front lower right, which were tested for the presence of blood and were negative.
Q41?
Q41 was identified as a shirt. It was a bright pink sleeveless turtleneck shirt, and that area was visually examined for any biological stains. There were none observed, so chemical testing was not performed on that item.
Q42?
Q42 was identified as a shirt. It was a light pink button-down, three-quarter sleeve collared shirt. A visual examination was performed on that item, and there were no stains observed, and therefore no chemical testing was performed.
Okay, and Q43?
Q43 was identified as a shirt. It was a green button-down, three-quarter sleeved collar shirt, and a visual examination was performed on it. There were no biological stains observed, and therefore no chemical testing was performed on that item for blood.
Was there any blood on any of the clothing that you received from the Anthony home?
No, sir, not on those items.
Did you receive any other clothing that's not in this report that you tested?
From the home?
Yes.
No, sir.
Okay, I'd now like to take you to the next item that you tested, Q44, which is State's Evidence 323. Can you tell the ladies and gentlemen of the jury what that is?
Yes, sir. Q44 was a piece of the spare tire covered, and it was a gray carpet cutting. And Q45 was a piece of spare tire cover as well, and it was also a gray carpet cutting.
Okay. And Q44, what did you do with that item?
That item had some extremely faint brown dingy areas on it that were spot tested for the presence of blood, and they were negative for the presence of blood.
Did you do anything beyond that?
On that particular item, it was actually combined with the next item for DNA testing.
Okay. Let's go to Q45, which is State's Evidence 142.
On Q45, there were extremely faint brown dingy areas on that item that were spot tested or were tested for the presence of blood, and they tested negative as well.
Now, tell the ladies and gentlemen of the jury what you did with both of these items together after you tested them for blood.
On those two items, a swabbing was taken, just a regular cotton tip swab with water applied to it, and a swabbing was taken of the entire item, as well as the Q45 item, and those two swabs were combined and processed for DNA.
Okay. And can you tell the ladies and gentlemen of the jury what the results were?
There were no DNA typing results obtained from either of those items, and they were combined, so there was essentially no DNA as a result.
Okay. I'd now like to direct your attention to the report that you issued on October 9th, 2008. Just let me know when you have it.
I have that report in front of me.
Okay. Ms. Seubert, can you tell the ladies and gentlemen of the jury what item we're discussing and a description of it and the Q number?
From the October 9, 2008 report, the items of evidence that were examined were Q46, which was identified as a shovel, and Q46.1, which was a label from the Q46 shovel blade.
Okay. And for the record and court, the stipulation that we could describe these items without any objection.
That these are the items testified to by Brian Berner, the shovel testified to by Mr. Berner earlier in the case. We do agree. Thank you.
Okay. And could you tell the ladies and gentlemen of the jury what you did with the shovel?
Yes, the shovel was examined for the presence of blood. And so visual examination was performed on that to identify if there were any possible stains. There were some areas that were in fact tested on the shovel, and those areas were negative for the presence of blood.
Now, I'd like to direct your attention to your report of December 16th, 2008. I know you issued two, but I'll let you know which one specifically.
Before we leave this report, I wanted just to be sure the testing that we discussed was the specific to the serology, but there was also DNA performed on that. So I just wanted to be clear on that.
Okay.
With that.
And what were the results of the DNA?
There, a DNA profile was not generated. There was a sex typing result at the amylogenin locus or the location, but it did not satisfy the reporting criteria of my laboratory.
Okay. And just so we can explain that a little bit, when someone grabs and touches an item, DNA is left, correct?
It's possible.
Okay. But would the touching of how much DNA you recover depend on the item, how much force is used, and other factors? Can you tell the jury a little bit about that?
Objection, leading and compound question.
Sustain, rephrase the question.
Can you describe to the ladies and gentlemen of the jury a little bit about touch DNA?
Well, touch DNA refers to.
Let me object to the relevance since there was no, she indicated there was no profile found. I don't know the relevance of this explanation.
I think it goes through.
Overruled.
Well, touch DNA refers to a type of DNA testing where you expect to have very limited amounts of DNA left behind. It's on items that may not have had a lot of contact with an individual, such as perhaps a piece of paper. If you pick up a piece of paper and you hold that piece of paper in your hand for a little bit of time, it's possible that you've deposited some type of cellular material from your hand on that piece of paper. But in order to get a DNA result that is typable or usable, depends on lots of factors. How long you perhaps had that in contact, and if you are capable of leaving a lot of skin cells behind. And so that all comes into play when you're looking at a DNA result when we're talking about samples that have had limited contact.
Now, when we talk about levels of DNA, how is that measured?
Not sure I understand your question.
What are RFUs?
RFUs talk about relative fluorescent units.
To the relevance, could we approach?
You may.
Maybe that was trash.
Yeah, objection overruled. You may continue.
Okay, Ms. Seubert, you've already described to the ladies and gentlemen of the jury what touch DNA is, correct?
Yes.
What is low copy number DNA?
Members of the jury, can you hear Mr. Bass?
Yes.
Thank you.
Actually, if I can help. Okay. Can you hear me? Can everyone hear me much better? All right. Ms. Seubert, I'm sorry. Can you explain low copy number DNA?
So low copy number DNA is a type of DNA process where going into performing the DNA testing on it, the individual knows there's going to be a limited amount of DNA information there. And so there is a procedure that can be performed to enhance the DNA analysis process to make even more copies, which we haven't really talked about, in the PCR process. So it's actually adding on some of the molecular xeroxing during the polymerase chain reaction when you're actually making multiple copies of DNA to enhance the end result, the DNA profile. So going in, you know you're going to have a limited amount of DNA, and so you're actually enhancing your DNA analysis process to adjust for that to make more copies to generate a result. And with that result, there's certain evaluations that have to go into those results because of the nature of low copy number. Since you don't have a tremendous amount of cellular material at the beginning, there are some things that in the end that have to be evaluated in order to generate the reliable or to have a reliable result.
Okay. So when we say low copy number DNA, I know these two terms are used interchangeably at times, but that's incorrect, right?
That's incorrect.
Okay.
Right. Touch DNA can be samples where at our laboratory, if a firearm comes in and you think about the nature of when you hold a firearm and you put your finger on the trigger, your hand on the grip, you're coming into contact with it, but not necessarily for maybe an extended period of time. So that would be an area that we would swab, knowing that that's where an individual's had contact. I would expect perhaps to get a result for the deposit of skin cells, but I'm not going to enhance my technique to make more of those copies from my normal analysis procedures. I already expect to have limited amounts, but at the current, when I was in the unit, we didn't have procedures to perform low copy number, which is enhancing the analysis techniques.
Now, I want to skip ahead a little bit to when you actually get the readouts of the DNA results. Can you touch briefly on that? Because I don't want to get too technical.
So what the end readout or the profile is.
Correct.
Okay. Can I back up even a little bit more just to talk
Sure.
about the DNA process?
Sure.
Okay. Since we haven't talked about it, the actual DNA process, how that occurs is, let's talk about a swab. We've talked about doing a swabbing of the carpet out of the trunk, the spare tire cover. So that swab is put into a tube, and there are chemicals that are added because in order to do DNA typing, we have to get to the nucleus of the cell where all the DNA is housed. So those cells have to be broken open in order to really get to that DNA and unwrap it from where it's contained within the nucleus. And so we're able to do that by adding chemicals, and then that DNA is now taken through the process. And the next step after we're able to extract that DNA away from the item that it's contained on is what's called the polymerase chain reaction, the PCR. And what that is essentially a molecular xeroxing. It's like going to a copy machine and making billions of copies of that one page that you have, that you need copies of, but we're actually doing that at multiple locations on the DNA. We're actually looking at 13 locations on your DNA, and so we're taking all of those 13 locations and making multiple copies of the DNA that's present. And so the next step then is to actually utilizing an instrument, the DNA is put into a capillary column through a process called capillary electrophoresis. And this instrument has a very small capillary column where the DNA in that liquid form is injected into this capillary column, and we're able to detect it through a process using a laser. And we talked about those RFUs, or those relative fluorescent units. What that's telling me is it's signaling that there's DNA present. And it's able to send that signal to a computer, which is collecting all of that information, and then it's interpreted into a DNA profile. Much like if you've been to the doctor and you have a heart monitor set up and you get an EKG done, you see those peaks on the EKG machine. That's what essentially my end product looks like those peaks. And those are representative of the DNA profile from that initial test tube where we extracted the DNA out and we were able to remove it from the inside the nucleus of the cell. And now I'm able to see the end result and generated a DNA profile, which I now will use in my interpretation.
Okay. And what you get through your readout, which are called electropherograms, correct?
That's correct.
Okay. And what you get are some squiggly lines and some peaks, do you not? Among other things.
Yes, the peaks are what I'm most interested in.
Right. Okay. And what you talked about to the ladies and gentlemen of the jury are the 13 different locations of where you search for DNA, correct?
Correct, the 13 locations, yes.
And these are also identified as markers.
Correct,
Okay, points of interest, so to speak.
correct.
Okay. And depending on how much DNA there is there, will the peaks also indicate to you how much DNA is present at that specific marker, correct?
Correct. The RFU units will be higher depending upon the amount of signal that's being sent to tell the instrument that it's detecting the DNA that's passing by that laser and creating a fluorescence, which is being collected and is outputted into a peak.
Okay. So if you have, what are the cutoff levels for your laboratory when reporting out something as DNA being at that specific location?
To actually report a DNA type, the threshold for my laboratory at the time I was in the unit was at 200 RFUs. And that was our match interpretation threshold. So anything above 200, I could use to make a match with.
Okay. And there are other laboratories and other kits that can actually report lower levels, correct? That's just that 200 for you to report.
Relevance.
Overall, she can ask the question.
For you, that 200 level number, it's a determination made by your laboratory.
Right, that number was based on the validation by the FBI laboratory at the time when we were validating the instrument and the kit to do the DNA typing in the unit.
But it is common in other laboratories that sometimes the threshold can be lower. Is that correct?
Overruled.
Other laboratories will have different interpretation thresholds. That is correct.
Okay. And can you explain to the ladies and gentlemen of the jury as to what your threshold is to exclude an individual?
Any information that falls below that 200 RFU interpretation threshold can be used for exclusionary purposes. But there is one more threshold that's not depicted on your chart.
Okay, and what is that?
That is at 50 RFUs.
Okay, and what does your threshold with 50 RFUs mean?
50 RFUs is the threshold for where a peak will be labeled a peak. That is our peak amplitude threshold, which is based upon the validation of where a peak will begin to be detected in the FBI laboratory.
Okay. Basically, some people will call these other items down here noise or artifacts.
There are other laboratories that may in fact use the threshold below that 50.
Okay. And if in your laboratory, if you see something that's 50, you can call it a peak.
That's correct. That is when the threshold for identify or labeling a peak begins.
And would you consider the laboratory thresholds that the FBI uses as conservative?
The 200 RFU threshold it's a relatively conservative threshold, yes.
Okay. And the 50?
Conservative, well, it's based on the validation, so I would say that is a scientific threshold based upon the validation for when reliable results are generated.
Okay. Now, you told the ladies and gentlemen of the jury about you being able to call something at the level of 50 a peak, correct?
Correct.
Now, and that would give you an indication that there's something there, correct?
At 50?
Yes, at 50.
Correct.
But unless it reaches 200, you can't report it out.
If it is at the STR loci, cannot be used for inclusion unless it is above 200. There's an exception with the amylogenin or the sex typing locus where information can be used if it's below 200.
And to kind of bring it all together with what we've talked about with the shovel and some other items that we're going to talk about, when you say that you cannot report it, doesn't mean that there isn't some DNA there. It's just something that your protocols preclude you from making or giving an opinion on, correct?
Objection, based on the conversation with the council, with the court.
Okay, you can approach.
No, I say based on the court's earlier ruling. All right, real approach.
Yeah. Okay, members of the jury, there's going to be a brief legal matter we need to take up outside of your presence. I'm going to ask that you step outside. We will get back with you as quickly as possible. Okay, the jury is outside of the presence of the courtroom. You may proceed with the proffer.
Ms. Seubert, the amylogenin peak that was derived from the shovel, can you give us the RFU for that?
Certainly. On the swabbing from the shovel at the amylogenin locus, there was an X for the female that appeared at 55 RFUs.
Thank you. I think that answers our question, Your Honor.
If I may ask a question to clarify.
Yes.
The import of that then would be to,
Excluded as being from a man, but not identify it as a woman. Is that how that would be interpreted?
Well, it's at such a limited amount, I wouldn't be able to give any type of information pertaining to that.
Oh, so you can't draw any conclusions?
I cannot draw any conclusions from that limited information.
Judge, that would be my objection. It's a result from which scientifically no reliable conclusion can be drawn. Therefore, it would not be admissible. To tell the jury this and to ask them to somehow interpret it in some way different than the witness does would, I think, be improper.
If I may briefly respond, Judge, I'm not asking her to report the results or to identify that it came from a female. I believe the witness has already testified that if it reaches the 50 threshold, that is an indication that there is something there, that it is beyond a artifact. That is all that I am attempting to elicit from the witness. Nothing more, nothing less.
Question, what's the relevance of that? What difference does it make if there is something there that cannot be scientifically interpreted to mean anything? Then what is the relevance of it?
The relevance is that there is DNA there. Not sufficient enough for her to make a determination as to who it belongs to or what it is, but there is something there. And that is it, nothing more. Now, there's a huge difference between being able to report something, exclusion or inclusion. We're not discussing that. We're discussing whether DNA material, and the witness has already testified that if it passes the 50 threshold, that is an indication that there's something there. That's it. As far as now, if that is fair game for cross-examination, when Mr. Ashton wants to get up and say, you can't say this, you can't say that, you can't do this, and that's fine. But as far as what I'm trying to elicit from the witness is simply that there was a portion of DNA there, and that's it, nothing more.
Judge, the problem is, to what end? Is counsel going to elicit this and then at some later point argue to the jury that somehow that bit of DNA could have been amplified, could have been this, could have been that, without scientific support? Unless it is relevant to an issue, then it's meaningless. It's not relevant.
If it's not relevant, why is this shovel in evidence?
Judge, the shovel isn't evidence.
Mr.
Counsel knows why the shovel.
Mr. Ashton, calm down.
Sir.
Okay, calm down. Sit down for a second.
Yes, sir.
Okay, have you finished, Mr. Baez?
Well, my point is, Judge, this shovel has been brought into evidence. It is a relevant piece of evidence. There's testimony been admitted that Miss Anthony borrowed the shovel.
I'm not concerned. I'm concerned about her testimony and what she's going to say. Okay, you have anything else to say about her testimony?
Nothing further, sir.
Okay, Mr. Ashton, reply from the state of Florida.
Yes, sir. I still would submit that the fact that there is a scientifically meaningless result on a test isn't relevant unless it can be tied into some issue in the case. And my concern is that counsel is going to, without eliciting from a witness whether this could ever be used to do anything, argue to the jury something that we know is scientifically incorrect. I think it needs to be relevant for some argument or some issue before the court.
The converse to that, Mr. Ashton, is those are things that you can ask her in your cross-examination. Ma'am, the results that Mr. Baez is seeking to elicit from you, exactly what does those results mean?
All I can tell you, Your Honor, is that there is a peak there, and it is,
Is it DNA?
considering that the initial threshold of determining a peak is at 50, and that peak does appear above 50 RFUs, it is a peak and is consistent with an X at the amylogenin typing, or at the locus. So I have no other information other than there is a peak.
There's a peak and it is an X, you said?
Yes, sir.
Okay, and what does that translate into?
Well, it's potentially could be from a female, it could be from a male. It's at such a low level in my report for the conclusion that I gave is that it is, do not satisfy the reporting criteria, and no conclusion can be offered.
So you can't say whether it originated from a male or a female?
Well, with the absence of a Y peak, all I can tell you is there's an X there.
And you can draw absolutely no conclusions from that?
No, sir.
Okay.
For any conclusions of the witness, nor will I ascertain. The only thing that I was
Okay,
attempting to.
let me cut both of you short. Okay. I will permit you to ask the question. The state can clear it up in cross-examination, and then the jury can take it for whatever it's worth. Okay?
Yes, sir.
Anything else, folks?
Your Honor, may I ask a question?
Yes, ma'am.
And I don't know how the information will be presented, but it is at a level that, since it's not in my report, I would have to be speaking about the result from a table that's in my report if we're going to address that. That's in my case file to address that specific piece of information.
Okay. Anything else, folks?
Nothing further.
Okay, let's return to jury. Okay, state recognized presence of jury.
Yes, sir.
Defense?
Yes, sir, we do.
Okay, Mr. Baez, you may proceed.
Thank you. 1, 2. Okay. Can everyone hear me? Okay. Ms. Seubert, where we left off, and I'm just going to recap for a moment before I ask you my next question, is we talked about the different thresholds of how much DNA is present on your electropherograms, the readouts. And when we were talking about the shovel, you mentioned that at one of the markers, there was something that reached above the 50 RFU levels. Is that not correct?
Correct.
Okay. It did not reach the 200 level, and you did not have multiple markers or sufficient markers to be able to report it out, correct?
That's correct.
So is a fair statement that there is something there, you just can't report what with any degree of scientific certainty.
Sustained, rephrase the question.
Yes. What's the best way to summarize what's there and what's not there?
Well, at the locations that the short tandem repeats would be present at, the 13 locations, the DNA profile, a result was not obtained at any of those 13 locations. For the amylogenin or the sex typing locus, which would indicate male, female DNA, there is a indication present of DNA at that location, but it does not meet my reporting criteria.
Perfect. Okay. Now I'd like to direct your attention to the next report that you issued in this case on March 19th, 2008. I'm sorry, that would be 2009. And let me know when you take your time. Just let me know. I know you got a lot of stuff there.
Your Honor, could we approach the bench on this matter of
You may.
I have that report in front of me, the March 19th.
Hold on.
Oh, sorry.
Court reporter.
You may proceed.
Have you had sufficient time to get your documents?
Yes, sorry about that.
Okay. And you have your March 19th, 2009 report.
Yes, sir.
Okay. Can you explain to the ladies and gentlemen of the jury what these items of evidence were?
So items that were reported out on the March 19th, 2009 report were identified as Q62 through Q64 as tape, which were items from the medical examiner's office.
And for the record, this is State's Evidence 302. And are we talking about duct tape?
Yes, sir.
Okay. And these were duct tape items that you received from the medical examiner's office?
Yes, they were submitted to the FBI laboratory, and the origination of where they were collected from was identified from the medical examiner's office.
Okay. Can you explain to the ladies and gentlemen of the jury what you did?
On the items of the tape, they were examined, and there were three pieces, Q62, Q63, and Q64. And that the first examination was done on the top side of the tape. I'll refer to it as the silver side of the tape. And a cotton tip swab was taken, moistened with water, and the top side of that silver area was swabbed to collect any possible biological material that would be present on that silver side of the tape.
Okay. And when you say the top side, you're talking about the non-adhesive side?
That's correct, the top side, yes.
Okay. And were there any distinct markings on the top side of the tape to help you identify the item of evidence?
I have a description here that the manufacturer's logo, Henkel, spelled Henkel, was throughout the tape.
Okay. And did you get any results, any DNA results from the top side of the tape?
Yes, so the swab itself DNA typing was performed on that swab that was collected from those three areas of tape, and a DNA profile was generated. However, it was below the interpretational threshold of the FBI laboratory's reporting policy.
Okay. And when you say below the threshold reporting policy, can you give us how many markers were present, number one?
On the top side of the duct tape, or the silver side of the duct tape, an STR result, or the DNA typing result was obtained at 6 of the out of the 9 locations that were tested. And if I can just back up and describe that real,
Sure, please do.
for you. So in doing DNA typing, there's actually 2 typing kits. They're called amplification kits that are utilized to come up with the totality of the 13 locations.
Let me ask you, I'm sorry, Ms. Seubert, would it assist you to write would it assist you to use the board to kind of explain it a little clearer, or do you feel comfortable enough doing it from the stand?
As long, if it becomes confusing, you can let me know.
I don't know if the jurors can let you know. Well, Your Honor, may the jurors raise their hand if they're getting a little confused on the issue?
No.
I can list out the locations if that would be helpful.
That might be a little helpful. May the witness stand down, Your Honor?
Yes.
Okay. I can hold your papers if you want. Okay, sure.
Okay. So the areas that we've kind of talked about, there are 13 locations on the DNA, and they are selected because of their highly polymorphic, or they're very different between individuals. And they're actually located on different chromosomes. And we haven't talked about chromosomes, but you actually have 46, 23 of them came from your mother, 23 of them came from your father. And so on those chromosomes, certain locations have been identified as being highly polymorphic or different, that have been selected to be looked at in forensic DNA typing. And so within one of the kits, there are actually 9 of those locations that have been identified, and that we will amplify the DNA with, or target those locations, make the copies, and generate, if there's enough DNA there, a DNA result. And so I'm going to write out those DNA locations for you so you can see their names, and I can tell you a little bit about what each of those names means.
Can you see that, Mr. Asher?
I cannot see that. You could just push back just a bit. Yeah, that's fine. Right where you had it was fine.
Right there?
I can't see it.
Can everyone see it? Okay.
So what I've listed out here are each of, well, this is 9 of the locations that we would look at in one of the tests, or that are contained with one of the kits. And that kit that I've listed here is the Profiler Plus ID kit. And each of these locations, this one is D3S1358. D3 is actually on chromosome number 3, and it is the location. It's basically like its house address on the chromosome. If you think of the street that you live on, it's the main street, and it's kind of like the house number for the area that's been targeted. And so as you go down the line, you have VWA, FGA, D8S1179, D21, I'll shorten them, D18, D5, D13, D7, and then amylogenin, which we've been talking about as the sex typing locus, which will tell whether or not you have male or female DNA present. And so what happens during the DNA typing at the very end, as a part of my analysis, when I do my interpretation, I'm actually looking at the peaks that Mr. Bias talked about earlier at each of these locations. So at D3, I would actually look at if there are peaks present and what the DNA type is for each of those peaks, and then I would populate the table, which would represent the DNA profile. And what these peaks actually represent, and we've talked about, is DNA, but these are actually the short tandem repeats. They're STRs, which are the types of DNA repeats that are present at each of these locations. And so essentially counting up how many of those repeats are present at each of the locations that were examined.
And do you get one of those numbers from your mother and one from your father?
That's correct.
Okay. And what happens if both of your parents have the same one at that location?
So if your parents have the same STR type at that location, then you're going to have just the one peak. So for example, let's say if we'll call this D3 here, and let's say this is a 15, 16, and let's say we go to VWA, and there's just one peak there. That means both your mother and father have given you that one type, and then you would just be, we'll call it a 10. And so both parents have given you that 10 as part of your DNA makeup at that location.
So what we've looked at so far that you've written, in a hypothetical situation, this person would be a 15, 16 at this marker, and then a 10 at this marker.
Sure, and that's, yeah, so each of these markers, there'll be if there's enough DNA present to generate a result, there will be a peak or 2 peaks present if you have a single source sample.
And when you have the full combination of the 13, that is when you have a DNA profile.
Well, you can actually have a DNA profile just at one location. So you don't necessarily need all 13 to have a DNA result. It could just be at one locus, it could be at 2, it could be at a combination of them. And so I've only listed out 9 of the locations here. The second test actually has another series of these locations contained within it that are targeted. And that's where you get the additional loci would be in the next test or locations.
And depending on the marker, it tells you how discriminatory it is, meaning how many people might have that number at that location?
That's actually a different part of the process.
Okay. And I know we're kind of jumping ahead, but as it relates to the duct tape, what did you find on the non-sticky side of the tape?
In my report, I identified that there was an STR typing result obtained, but it fell below my reporting threshold. So if I list that profile here, it's gonna, if I can list it as such that it would be representative of a profile that I would only be, that would fall below my reporting threshold.
Okay.
If I can write it out that way, but indicate that.
Okay, that's fine. That's fine, we understand.
Okay.
Now, how many of these markers do you need to exclude someone?
It could just take one marker to exclude an individual.
Okay. In what you obtained, could you exclude Caylee Anthony?
Now we're talking specifically to this particular item.
Correct.
Yes.
Okay. So Caylee Anthony was excluded from what you got so far?
Yes.
Okay. And was Caylee Anthony excluded as well?
Yes.
Okay. Did you do something further to try and determine who this partial profile belonged to?
Yes, I did.
Okay. What did you do?
Well, after I had generated this DNA profile, I used all of the known samples that were submitted to the laboratory, the known blood samples that were submitted from Ms. Caylee Anthony, the known profile that we used for Caylee Anthony, as well as other family members that had been submitted. Cindy Anthony, Lee Anthony, George Anthony, and I compared those profiles to this DNA profile that I had generated. And all of those individuals were excluded from this profile.
Okay. Did you take it a step further? Actually, we could probably get you back to the witness stand.
Thank you.
Take that from you so I can give it to Steve. What was the next step that you took to try and determine who this might be?
Well, based upon the generation of that profile in it, and I had excluded the known samples that had been submitted as a part of this case submission, the next step was to evaluate the staff database that was maintained of the DNA analysis unit. So the individuals who work in the DNA analysis unit will provide a sample and will maintain a database of all of those types to compare when a profile is generated to determine if it could be one of the staff who'd worked the case or who are working in the laboratory.
Okay. And did you find someone that matched all of these different markers?
Not, and they're not from the DNA analysis staff database. No, I did not.
Okay. What did you do to, what further did you do?
The next step that I did was I determined what other units at the FBI laboratory had processed this item of evidence. And knowing that the profile I had was a female profile, I started looking at specifically any female female examiners or technicians that would have handled this item. And so working with the evidence control unit, I was able to identify which units this item had been processed in, and I contacted those individuals and asked if they would give a DNA sample.
And did they?
Yes, they all did.
Okay. And who did it turn out to be?
This profile was matched to Lori Gottesman, the question document unit's examiner.
Okay. Now, this is, well, let me ask you this first. Is it possible when you contaminate DNA that it may overwrite DNA that's already there?
Well, it would depend on the quantity of the DNA that you're suggesting is the contaminant. So there would be some factors that would have to be considered with that.
Okay. Explain those factors.
Well, depending on the quantity of DNA, if you have a very large quantity of DNA, it is possible that it could shadow or hide the very small presence of DNA from another individual. However, on this specific item, the profile itself is at low levels, and so if there had been an additional individual present, I would have expected to see a mixture at some of those locations.
But that would only include if you had various, a large enough amount of DNA to account at different markers, correct? Meaning if you only had 2 markers and this DNA overrode that, or just one, it is certainly possible that this would overshadow any DNA.
Objection, it assumes hypotheticals, not based on facts and evidence in this case.
Sustain, rephrase the question.
Yes. If it's still possible that that this contaminant could have contaminated other DNA that's there, correct? At lower levels?
I would have expected at the levels that this profile is at, if there was an additional profile there, I would have expected it would have been mixed with another profile if contained there.
And what if that profile that might be there would be at such a low level that it got overridden with this? Is it still possible?
Objection, hypothetical, not based on facts and evidence.
I'm asking her a scientific question, Your Honor. She
But
can
it's still a
answer it.
hypothetical that's based upon facts that are not in evidence, and I would submit improper.
I don't think, Your Honor.
Sustain. Yes.
Okay, let me ask you this. Can contaminating DNA override something that's already there?
Objection, that's an answer.
Overrule, I'll let her answer the question.
This is a hypothetical. If you contaminate an item, can it override DNA that's already there?
If the presence of a very large, if you have a very large volume or percentage of DNA deposited on an item in a very small amount of a second individual, it's possible.
Okay. Now, the item of evidence got to the DNA lab, much later through the processing of this duct tape, did it not?
We were the last units, yes.
Okay. Is that common?
Not sure how to answer your question if it's common.
Sure. Would it have been more advantageous for DNA to get the duct tape first, the DNA lab to get the duct tape first before other technicians had already had access to it and potentially contaminated it?
It wouldn't have altered the way that the tape would have been processed in my unit.
Okay. But it would have reduced the possibility of other people contaminating the duct tape.
Well, anytime an item is handled by fewer people, there's a less of a chance of another or of individuals' types being deposited on that item. So sure, the fewer people that handle an item, the less chance there is of a contaminant or another DNA profile being deposited on it. But that still didn't change the way that I would have processed that item.
I understand, ma'am. From your understanding, how many divisions and people got to this duct tape and processed it before you got it?
Well, the examination plan is developed by the evidence control unit for the movement of items in the laboratory, and that's where the decision is made for the movement of items in a case. And so on this particular item, there were several different types of examinations that were going to be performed. So it went through the trace evidence unit, the chemistry unit, latent print unit, and the question document unit prior to the DNA analysis unit receiving it.
Okay. Now, it was your understanding as well that the duct tape had been exposed to numerous elements, right?
The case information did describe that the location of where the evidence was collected from was outside and would be have water in it at times, and so it was conveyed in the incoming letter that it was outdoors.
Now, the elements do and can degrade DNA, does it not?
Objection leading.
Overruled.
Sure, the elements, sunlight can destroy or deteriorate the DNA that's present, humidity, those several different factors of being outside could impact the amount of DNA that would be left on an item.
So why do you then do the tests?
Well, based on the item itself as being evidence, in this case, it was my thought that from a forensic standpoint, the item should be swabbed to determine if there was any DNA present on that tape that was left on the victim.
Okay. And you can still get DNA even from items that are underwater?
Objection.
Can you not?
Sorry, I thought it was objection leading.
Question calls for a yes or no answer. Chaz, can you get DNA from an item that's underwater?
I don't believe that was the question as phrased.
I believe it was, Judge.
And you still get DNA even from an item that's underwater?
Yes, sir, that's what I objected to leading.
Overruled. Can you answer the question, ma'am?
In a yes or no fashion, Judge?
It calls for a yes or no answer? Unless you need to explain.
If I could have the opportunity to explain.
Go ahead.
Okay, thank you, sir. It's possible, but there, again, would be several different factors that would be involved in the length of time an item has been submerged, what type of biological fluid, was it blood, is it semen, is it other types of biological fluid that were present on that item. So there are several factors that would be considered into whether or not you would be able to obtain a DNA profile from something that has been submerged underwater.
And in fact, you can also get DNA profiles from people who've been burnt victims, can you not?
Sustain.
Do you know if you can get a DNA profile from someone who has been burnt or a burnt victim?
Yes, sir, you can.
Okay. And are there multiple variables that could determine whether a DNA profile can be generated?
Sure, there are variables that the generation of a DNA profile would have to be considered. Sure.
Okay. And is it fair to say that you never know what all the variables are until you actually test it?
Objection leading.
Sustain, rephrase your question.
Yes, sir. Would you know what all the variables are of a specific item before you test it?
No, I don't have all the knowledge of an item prior to its coming to the FBI laboratory.
Okay. So is it possible for you to know whether you'll get DNA from an item unless you actually test it?
Can I answer that outside the yes or no, sir? Well, that would depend. If it's a blood sample that is a red-brown stain, I expect to get a DNA profile from that reddish-brown stain that I've concluded is blood. If it is a general swabbing on an item that I've not identified any biological staining, but I'm trying to collect biological material, in that case, I don't know if I'm going to generate a DNA profile.
Okay. And when dealing with duct tape specifically, where would you expect to get a profile? Where would you expect to get a better chance of getting a profile? The outer portion for the person applying the tape, or the inner portion where it might be attached to someone's face, saliva, and other bodily fluids might be getting on it?
Objection to a hypothetical is inapplicable to this case.
Because of the environmental factors.
Overruled.
Could we
Please.
approach for just a moment? I just want to,
Yes.
thank you.
I'm sorry, I forgot where I left off. Can I ask the court reporter to read back where we were, Your Honor?
You may.
Question, when dealing with duct tape specifically, where would you expect to get a profile? Where would you expect to get a better chance of getting a profile, the outer portion for the person applying the tape, or the inner portion where it might be attached to someone's face, saliva, and other bodily fluids might be getting on it?
Can you answer that question, ma'am?
Yes.
Okay.
The higher likelihood of where the DNA profile would be generated from would be from the underside, where it's actually coming into contact with an individual's face, saliva is being deposited on it, so there's cellular material coming from from saliva.
And if it is attached in a violent manner, it would also have skin tissue attached to it, would it not?
I'm not sure that I understand the violent manner.
If it was put on firmly, tightly, that would have skin tissue on it, correct? Or you would expect to find skin tissue on it?
Well, just the contact from the tape being placed on on a person's face, you think about the adhesive, and just like when you pull a Band-Aid off, that hurts, and it's what you think what it's taking with you are, you know, part of the cellular material on that topical surface of your skin. So you think about the same adhesive contained in a piece of duct tape being placed on the face, the same type of adhesive is taking place with the contact.
Okay. And did you test the adhesive side of the duct tape?
Yes, I did.
And was there anything that you were able to find there?
The information that was generated was inconclusive.
Okay. Were you able to find was there a readout at a D3 marker?
There was a peak detected at the D3, yes.
Okay. And can you write down or tell us what number that peak came to?
Yes.
You can just say it.
Okay, it's a 17.
17. Do you know if Caylee Anthony is a 17 at the D3 marker?
I'm going to take a moment just to retrieve my profiles. at D3, Caylee Anthony is a 14-15.
Okay. So she does not have a 17 at that.
No, sir.
And if you had a 17 at a D3 marker and she is a 14-15, could you exclude Caylee Anthony as being a contributor to that?
Yes, she does not have a 17 at that location.
Okay. And what about Casey Anthony?
Caylee Anthony is a 14-15 at the D3 location.
Okay. So she also does not have a 17 at the D3 marker.
That's correct.
Okay. And when you have one marker that does not match an individual, can you exclude them from being a contributor to that DNA?
Yes.
Were you given the DNA profile of anyone else other than members of the Anthony family?
Yes, I was.
Okay. Who else were you given?
We have to object at this point. This is items that are not in evidence, I believe.
Are they in evidence?
No, they're not, Judge. I'll withdraw the question.
Okay, thank you.
The Okay, I guess that's everything that concludes the March 19th report, correct?
Yes, sir.
Okay, let's move to your next report on July 24th, 2009. Just take your time. Let me know when you have it.
Can you repeat the date again, please?
Yes, July 24th, 2009. I believe that's from my draft, but you have it as August 19th of 09.
Yes, thank you.
Okay. Can you identify to the ladies and gentlemen of the jury what items, the first item that you received on this report?
Yes, the first item that was received is identified as Q80, which was a pair of shorts.
Okay. And for the record, this is State's Evidence 269. And where did these shorts come from?
These shorts, the shorts were identified as items from the medical examiner office.
Okay. And what tests were done on those shorts?
On the Q80 shorts, the item was examined for the presence of blood and semen.
Okay. And what were the results? Were you able to confirm blood or semen on the shorts?
No, both of those tests were negative for the presence of blood and semen.
Okay. And then on, what's the next item that you received?
Q81, which was identified as clothing.
I'm sorry, we're going a little too fast.
Sorry.
It's my fault. Okay, and when you refer to clothing, you're referring to the item which would include the shirt, which was like the elastic portion of the shirt and the letter writings of a child's shirt?
Yes, I can read my description if that would assist.
That would be better. Go ahead.
I have it identified as containing letters, stitching, and stretch material with the letters being spelled or containing BIGTROUBLE. And there was also some stick and other debris contained with that item.
Okay. Were you able to confirm blood on that item?
No, I could not confirm blood on that item. The chemical test for the possible presence of blood was positive. However, there was insufficient quantity to continue on and confirm the presence of blood.
Okay. So you can't say in any way that there was blood on there?
Only that the possible presence of blood, that it was positive for the possible presence of blood.
Okay. And was that tested any further?
Specimen Q81 was continued on for DNA typing.
Okay. And out of that, what you thought was possible, were you able to come up with a profile?
No, sir, there was no DNA obtained from that item.
Okay. And what's the next item?
The next item is Q82, which is identified as a blanket.
I'm sorry?
It was identified as a blanket.
Okay. And on the blanket, were you able to confirm blood on that blanket?
Could not confirm the presence of blood. However, the chemical test for the possible presence of blood was positive.
Okay. And did you then take it a step further to see if there was DNA there?
Yes, that item was swabbed for DNA testing, and no, there was no DNA profile generated from that specimen.
Okay.
There was an additional chemical test also performed on that blanket.
Okay. And what other test was done on that blanket?
That item was also looked at for the presence of semen.
Okay. And did you find any?
No, that item was negative for the presence of seminal fluid.
Okay. And the next item?
The next item is Q84, which was identified as a laundry bag.
Okay. And that laundry bag, what test did you run on that?
The chemical test for the presence of blood was performed on that item, and it was positive for the possible presence of blood. However, there was insufficient quantity to continue on for a confirmatory test.
Okay. And did you then take it a step further and try to get DNA?
Yes, sir. DNA typing was attempted on that item. However, there was no DNA typing results obtained.
Okay. And then the next item?
The next item is Q103, identified as a blanket.
Okay. And what test did you run on that?
That item was tested for the presence of blood and semen.
Okay. And what were your results there?
The chemical test for the possible presence of blood was positive on the blanket, and the tests for the presence of semen were negative.
Okay. Okay. And can you give a better description of, actually, if I can have a moment to prefer. Your Honor, my apologies. The blanket that was just described is not an item that's in evidence. It's completely unrelated, and I wanted to move to strike that on my own and the references to that.
And this would be as to which Q number?
Q103.
So I agree the jury should disregard any discussions about Q103. It has nothing to do with this.
And it's completely my error. Mr. Ashton and I had spoken previously in the process of going
So
through.
that's the blanket that she's just testified to?
Correct.
Ladies and gentlemen of the jury, you're hereby instructed to disregard testimony that the witness has given concerning the blanket that she's just testified to and not utilize that in the decision-making process in this case. You may continue. Thank you, Mr. Bias.
Thank you, sir. Ms. Seubert, there are other items on your report that are not in evidence, so I have to ask you specifically for which ones, okay?
Yes, sir.
And testify only to those. Can you also tell us about Q244?
We identify that with the
Yeah.
Number so that we make sure we.
That is,
Exhibit HR.
States Exhibit HR. Can you tell us, give us a description of Q244?
Yes, Q244 was identified as a doll that was received at the laboratory.
And where does the doll, where were you informed the doll came from?
It's identified that the doll was collected from a vehicle, and I can check my notes to determine what vehicle specifically.
Sure, go ahead. Can we both stipulate it's the Pontiac Sunfire? Your Honor, we have a stipulation that the doll came from the interior portion of the car on the car seat.
Which car?
The Pontiac Sunfire.
Okay.
In the car seat, in the back seat passenger of the car.
Yes, okay. Can you tell us what you did with that piece of evidence?
That item was generally swabbed for the presence of blood, and that test was negative. So there was no blood identified on that item.
Okay. All right, I want to take you now to your next report, which is December 16th of '08.
Is that a long report?
No, I believe I'm just got a couple minutes, and then we can take a break. Take a break.
Okay, go ahead.
I'm aware we're close.
Sorry, can you state the date one more time on that
Yes,
report?
December 16th of 2008.
I have that report in front of me.
Okay. On page 2 of your report, were you given the profiles of Cindy, George, and Lee Anthony?
If I may refer to one
Yes,
other.
go ahead.
The question that you had asked was if I had been given the profiles from Cindy, George, and Lee Anthony.
I'm sorry, buccal swabs from them.
Correct. The buccal samples had been submitted to the laboratory under communication dated October 20th of 2008.
And and I'm referring to State's Evidence 113, were you asked to conduct a paternity test for Lee Anthony as to Caylee Anthony, being the potential father
We
of
approach.
Caylee Anthony?
You may. 11:59. We're going to recess for lunch. I'm going to ask you not to discuss this case among yourselves nor with anyone else. Enjoy your lunch. You may be seated. Okay, Mr. Ashton.
The objection, Your Honor, is that counsel has no good faith basis for asking this question. He is aware, fully aware from depositions that the FBI laboratory does not perform paternity testing, that they were never asked to perform a paternity test on this case. And in fact, well, I'll let counsel respond and deny either one of those things I just said.
What is your good faith basis for asking the question that you were asking? Just a second.
Two things. Yes, sir.
Just a second.
Sure.
Pardon? I was going to find it, but if you can find it quicker than I can.
Were you asked to conduct a paternity test for Lee Anthony as to Caylee Anthony, the potential father of Caylee Anthony?
I have two very good faith reasons for asking that question. Number one, it was tested to see if Lee Anthony was the potential offspring, if Caylee Anthony was the potential offspring of Lee Anthony. And number two, I asked this witness last night. The FBI does not normally do that, and that's what she will testify to, that they don't normally do them, but they can do them, and they did. And as far as the statistical analysis portion, they would have to refer it out to a second laboratory. So that's exactly what the objections raised by Mr. Ashton are not true. The FBI in this case did do a paternity test, but he was excluded as the potential father. And end of story. I don't understand where, if it's in black and white in an actual report, how that's not a good faith basis. And I also mentioned this when we were at the break, the items of evidence. I would assume that Mr. Ashton, knowing that it says that in this report, and we identified the actual item, that it was an area I was going to inquire about.
May I ask the witness a question, Your Honor?
You may.
Were you ever asked to do a paternity test to determine if Lee Anthony was the father of Caylee Anthony by the state or by Orange County or by law enforcement?
If I may refer to my communication log for the conversation that I had with the special agent in charge before I answer that, to be clear.
Go right ahead.
You may.
Thank you. I have the conversation here noted, if I may read that to answer that question. On September 12th of 2008, I spoke with Special Agent Nick Savage. The inquiry about paternity testing / reports, I let him know we could run sample, generate results, and send our report to a laboratory for the statistical component. And this is referring to the lab. It has been a lab that has assisted us in the past, and he agreed. They do not have the sample yet. That's
Does that in any way mention Lee Anthony?
no, sir. Not in that particular conversation, no, sir.
Your Honor, that is my objection. While counsel is correct that by looking at the DNA profiles that were run, Mr. Lee Anthony and George Anthony can both be excluded as potential fathers for Caylee. But to ask that question, suggesting that law enforcement specifically inquired, is not a good faith question. If he wants to bring out that, in fact, coincidentally, these test results exclude them as the father, that's fine. But to suggest by that question that that request was made by law enforcement, there is no good faith basis for that. And also, of course, it's hearsay. What a police officer may or may not have suspected or had a question about is not relevant in this case, and counsel has no good faith basis for believing that it is.
May I inquire as to the witness, if it's
You may.
necessary? Who did you understand they wanted you to compare the paternity test for?
Before I answer that question, there is one more entry that I wanted to read prior.
Go ahead,
Sure,
man.
go ahead.
So on October 8th of 2008, I also had an additional conversation with Special Agent Savage. And within that conversation, he would like us, it is stated, he would like us to submit the brothers' results with Caylee and Casey to the UNT lab. A possibility of parentage is present in the results.
So it was your understanding that you were to determine if Lee Anthony was the father of Caylee?
The question had been posed if we could run the samples and generate a result and do a comparison. Specific to paternity testing, our laboratory does not perform. However, we could have made the determination as a possible biological offspring or excluded as a possible biological offspring, and had identified the laboratory that would perform the statistic component if that had been a possibility.
So you run the test if he's a potential, if he's potentially the father, it would be sent off to another lab for the statistical component.
For this particular discussion, that was what had been laid out for this particular, these samples.
And in your report, do you report out that that based on the SDR typing results, the DNA obtained from specimen Q18-1, Caylee Anthony, could not have originated from a biological offspring of the individual represented by specimen K9, Lee Anthony?
Yes, that is stated in that report.
The objection then is, what is the relevance of what a particular FBI agent thought or a question that he had? What is the relevance of that other than to suggest to the jury that there's some information out there that this jury has not heard? How is the good faith basis relevance of that?
I never asked that question, Judge. I'm going through her results like and through the work she's done in this case. That is part of the work she's done in this case.
That is not the question counsel asked, and he darn well knows it. If he wants to ask this witness whether Mr. Lee Anthony is excluded as the father of Caylee, that's fine. That's in the report. More power to him. But that wasn't the question he asked. That wasn't the implication he was trying to leave with this jury.
Anything else, folks?
Not really.
Let me say this. I don't know what was in your mind. I don't know what was in Mr. Ashton's mind. But you are not to ask questions that may lead to inference that unless you want to call a law enforcement officer to ask that he specifically asks to have something tested, you can get the results as Mr. Ashton has indicated. That's a proper question. I'm not going to even venture a guess or speculate on the motivations or whether or not your question even suggested that. I would do what I told both sides to do some time ago. There's a case called the Amante Banana Company, which is found at 466 7th 2nd, page 1167. Read it. It talks about good faith basis for asking questions. There's another case, Broxson versus State, which is found at 505 7th 2nd, 1361. Out of the First District Court of Appeals. Please read those two cases for a good faith basis for asking questions, and that's all I'm going to say. Okay. If there are other exhibits you need to line up for afternoon witnesses, please let the clerks know. So those exhibits may be pulled. We'll be in recess until 1:30. Yes?
Motion to strike, I'd ask to strike counsel's last question and have the jury, when they return, be instructed to disregard the question.
Folks, I will look at the question, but all I'm going to say is this. I don't have a hearing problem. And the amplification of questions, objections, I don't need them. Okay? I can hear in normal voices. Okay. I will ask the court reporter to mark the last question. I will review it when I come back, and I will consider that. Okay, we'll be in recess to 1:30. You may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys, both sides ready to proceed.
Yes, sir.
Okay. Now, do we know what your next question is going to be so we don't?
Well, that's the, I want to know, I don't want any issues, so I want to know how the court.
The last question you asked you asked the following question before we went to sidebar.
Mhm.
Were you asked to conduct a paternity test for Lee Anthony as the Caylee Anthony, potential father of Caylee Anthony?
Yes, sir.
Okay.
That's what I believe she was asked to do. I don't know if.
And Mr. Ashton, your objection, sir.
The objection is, it is not relevant whether anybody asked that question. The relevant is whether a test was done and what the result were. The
rephrase.
question. Sorry, go ahead, sir.
One
My
at a time.
apologies. My apologies, sir. That was my fault.
No, you go ahead.
I
Mr.
can
Ashton?
rephrase.
Okay.
I can rephrase the question. Did you conduct a paternity test for Lee Anthony? Not. I won't ask if she was asked.
Okay.
And
All
then-
right. Since we're now all on the same page, let's return to jury. Okay, state recognized presence of jury. And the defense?
Yes, sir. We do.
Okay, members of the jury, did you heed all of my previous admonitions during the noon recess for lunch? Okay. Apologize for starting late, but we had elevator problems. All right, Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Ms. Seubert. Sorry.
Good afternoon.
Where we left off, I wanted to ask you if you conducted what would be considered a paternity test to determine if Lee Anthony was the biological father of Caylee Anthony.
Can I have the date of that report one more time?
Sure.
That we're discussing?
That's December 16th, 2008.
And you said December 16th, 2008?
That's what I believe the date. Yes, that's the date I have. And I would be referring you to page 2 and 3, specifically 3 of your report.
I apologize. I had that report out earlier prior to the recess, and I'm just trying to find that one again. I apologize.
No problem.
I have the December 16th, 2008 report in front of me, and you're directing me to page 2.
I believe you start on page 2, but the results of your examination are on page 3.
The report I have dated December 16th, 2008 does not address the question that's,
I know you have 2 reports that.
okay.
You might look at the other one.
Would it be okay if I looked at the report that you had in front of you?
May I approach the witness, Your
Oh,
Honor?
thank you, Your Honor.
Thank you.
If I may have a smoke, Counsel?
Yes. Go ahead.
And can you read to the ladies and gentlemen of the jury, page 3, with your results?
Yes, on page 3, it states, based on the STR typing results, the dean, apologize. Based on the STR typing results, the DNA obtained from specimen Q18-1, Caylee Anthony, could not have originated from a biological offspring of the individual represented by specimen K9, Lee Anthony.
May I approach the witness?
You may.
Now, these types of tests are not done very often at the FBI laboratory, are they, ma'am?
Objection, relevance.
Relevancy?
Just explaining the evidence a bit more, Judge.
Sustained.
Okay, let's move on to that same report, which you don't have. May I approach the witness again, Your Honor?
You may.
I have found it now, thank you.
Can you explain to the ladies and gentlemen of the jury what Q47 is? And just for the record, the defense and the state have entered into a stipulation to discuss these items without objection.
Does Q
The car, yeah, that's good.
47 have a reference exhibit number?
It would be identified as.
And we would stipulate that it is the car seat, which is shown in the photographs from the Pontiac Sunfire.
Okay, thank you.
Thank you. Can you tell the jury about the car seat? What you did?
Yes, I can. Q47 was identified as a car seat from the 1998 Pontiac Sunfire, and that item of evidence was examined for the presence of blood, and the chemical testing performed was negative.
Did you do anything further beyond testing for blood?
On Q47, the car seat, no, I did not.
Okay. And Q48, can you tell the ladies and gentlemen of the jury what that is?
Q48 was identified as the steering wheel cover.
And what did you do with that item of evidence?
We would stipulate it's the steering wheel cover from the Pontiac Sunfire steering wheel, just so the jury knows what we're talking about.
On that particular item, it was visually examined for the presence of any biological stains. And through the visual examination, there were no biological stains observed, so therefore no chemical testing was conducted.
And Q55 and 56, can you identify what items they are and where they came from?
Yes, Q55 was identified as debris from the spare tire wheel well. And Q56 was identified as a swab from the spare tire wheel well.
Okay. And other than the other report that we covered that is dated the 16th, which deals with identifying Caylee, have we gone over all of your reports?
Yes, sir.
Okay. I have no further questions for this witness.
Cross-examination?
Good afternoon.
Hello.
I want to take some time and go through what these results mean or don't mean.
Okay.
Let's begin with the Exhibit 15 in evidence, which is identified as the swabbings from the spare tire cover. All right? You indicated that you did a phenolphthalein test on that, which is a presumptive test for blood.
That's correct.
What does the phenolphthalein test actually react to in blood?
It is actually reacting with the heme portion of the blood.
And when you say the heme portion, can you let us know what you mean by that?
Sure. It is part of the substance that's carried along on the red blood cell that we're actually looking for. And it's basically a test where it's an oxidation reduction test. I know it sounds kind of technical, but it's a test where the first chemical that's applied is going to react with the heme, and then once you add the second component, it actually oxidizes it, causing that color change if the heme portion is there and is present.
And is the heme portion only found in intact red blood cells?
Well, it could certainly, if you had some broken down red blood cells, if it's still attached there, you could have some residual that could be present. But as you start to break down the red blood cells, you're starting to then also break down the heme portion that's present.
So when a body decomposes, blood decomposes, the hemoglobin also decomposes.
That would be a correct assumption, yes.
Is this test in any way indicative of whether a certain substance is fluid of decomposition of a human body? Is it sensitive to that, other than if there's whole blood cells?
Not sure if I understand.
Let me rephrase it. That was a little sloppy. Would this test react to other substances in the body like fat?
If there was any type of presence of that heme portion from the blood that could be connected when you talk about where fat is deposited, it is possible.
Okay, but only if there's relatively intact red blood cells.
Correct.
But if the blood cells have decomposed, then it wouldn't react, or it's less likely to react.
Less likely.
Okay. I guess what I'm getting at is the particular stain that you tested has been identified as being decomposition fluid from
Objection, Judge. Assumes facts not in evidence.
Overruled.
has been identified as a stain from fluid from decomposition of a human body. Does your
Objection, misstates the facts, Judge.
Overruled.
does your test refute that?
Well, I can't speak to whether or not there was a blood or decomposition fluid present there because my test is negative. So I can't.
All we can say is your test did not detect whole blood cells.
It didn't react with any type of substance that was present there. Whole blood cells that maybe were, as we talked about, partially broken down. So I have nothing that would indicate that there was blood contained on those items.
But you indicated it could be decomposed fluid, including decomposed blood, that might not react to
Well, the
phenotypic
test,
It's the testimony of the witness.
Just-
Witness never testified to such a thing.
Objection sustained. Rephrase your question.
I guess what I'm trying to figure out is, does your test indicate that the stain was not the fluid from a decomposing human body, in your opinion?
based upon my testing results, it's negative, so I can't testify to anything other than the evidence that was there that I tested was negative for the presence of blood, which I can't state anything other than I didn't detect any biological material, blood, or other fluid based upon my results.
Could the stain still be decomposition fluid?
Overruled.
As far as if there were other biological fluids that could have been present in there, it's possible.
Okay.
But based on my test, I can't say anything other than it was negative.
All you can say is it wasn't blood.
Correct.
Okay, I've got that straightened out. Now, what happens to DNA when cells decompose?
Well, as cells decompose, the DNA is going to start to also be degraded. Because if you think about where the DNA is housed inside the nucleus of a cell, if the cells start to break down, eventually it's going to get to that center portion, the nucleus, which is also going to cause the DNA over time to also start to be diminished, losing the information that's present.
And in order for DNA testing to work, you have to have intact strands of DNA.
Right. With the 13 locations that I examine as a part of my analysis, if I have portions of those locations still present on the chromosome, I may be able to obtain a result.
But generally, with decomposing cells, you don't generally expect to find DNA.
Sustained.
I'm sorry, Your Honor, I don't believe she answered that exact question. It is cross-examination, Judge, so I would ask for some leeway to get,
One more time.
if I get the court to read back the question.
But generally with decomposing cells, you don't generally expect to find DNA?
Right. As the body breaks down, that information that's housed in the nucleus of the cell is also going to start to break down. And so the likelihood of obtaining a DNA result does start to diminish as the body starts to decompose.
Now, I want to go to this chart. I don't think I need you to step down. I think you remember when it was written. I want you to clarify for the jury what this result means.
Yes, you may.
This result that counsel wrote on this chart is 50. Well, I guess 55 was the RFU. What does that really mean?
Okay, so the two numbers that are circled there, the 50 is what's referred to as the peak amplitude threshold, or the first level of detection for what's considered a peak in the FBI laboratory's DNA analysis unit, which was based on validation and testing to support what's a reliable result in the laboratory. So during the capillary electrophoresis process, when the DNA is injected into the capillary column and the DNA strands are traveling through that capillary column, at the end there is a laser. And those DNA strands have been tagged with a fluorescent tag, which enables then that laser to detect the signal of that DNA strand as it passes by. And that's the fluorescence that's then collected. And that's the end result, that DNA profile, based on how much fluorescent was detected at each of those locations, which is then generated into the peaks that we talked about at each of those locations. So at 50 RFUs, that's when the computer interprets if there's enough signal there to determine that a peak can be called. That's the first initial. It's seen, it'll flag it as a true peak. And that is based, again, on the parameters that we've set at our laboratory to determine it is a peak. The next level.
Let me stop you for a second, because you kind of answered. I wanted to ask you specifically about the 55 peak that Mr. Bias was asking you so much about. In the context of this evaluation of this evidence, what does that mean, if anything?
A peak at 55.
The one you talked about the amylogenin peak at 55.
So a peak at 55, depending on which location it's detected at, and in this case was discussed, it was at amylogenin. Again, there's a peak detected, but it's only a sole peak at amylogenin. And so based upon the information of that I collected from that, determined that it was inconclusive. I cannot give any information about what that peak exactly means.
The amylogenin is a specific chromosome. You're looking at the sex chromosomes, correct? The
That's
chromosomes.
correct.
And this particular result you got is consistent with either being a male or a female. You just can't tell.
Well, the only part of that sex chromosome that's appearing is the X. There is no Y. And it is at a limited level, I felt it was more conservative to say it was inconclusive. There's just information about one peak there, but is it any information that I can give weight to? I couldn't state that, and therefore I said it was inconclusive.
Now, just so the jury doesn't misunderstand, does this mean that there is potentially an entire DNA profile there that could be enhanced with one of these other techniques that counsel was talking about?
Well, to perform low copy number, that would have to be the initial beginnings at the very start of the DNA analysis. So that would be an enhanced DNA process that the time I was in casework was not being conducted. And so if you were to take that same sample and perform a low copy number technique on it, I don't know what type of result would be generated. I can't speak to that.
It would be complete speculation to say that this would mean anything.
Right, I don't know.
But even if this were enhanced to a readable portion, it would only tell you whether it was a male or female.
Again, I don't know. It's possible, but I don't know.
Okay, there was a discussion about a single result on the sticky side of the tape at a 17 loci. Is that correct?
At the locus D3, it was a 17 allele. Again, well below the threshold.
Well below the 200 threshold.
Correct.
All right. Was there one of the individuals that you tested at the laboratory who had contact with the tape?
May I approach?
Yeah. Okay, ladies and gentlemen of the jury, I'm going to permit Mr. Baez to ask an additional question that will provide some type of clarity to an issue. You may proceed.
Thank you, sir. Ms. Seubert, we're talking now about the 17 marker, the 17 allele that is on the D3 marker on the sticky side of the duct tape.
Okay.
Okay. When you saw this, did you attempt to eliminate other individuals other than Casey and Caylee Anthony?
Yes.
Okay. And what did you do to attempt to do that?
The same process that I did with the top side of this tape, I would have done with the underside of the tape, where I would have compared that type at that one location to all of the reference samples from the laboratory personnel, in addition to the known samples that had been submitted as part of the case that I mentioned previously.
Okay. And this is a little different because you only had one marker, correct?
That's correct.
Whereas with the other one, you had 6? You're just clarifying it all up, Judge.
Let's get to the point. Objection overruled at this point.
You can answer the question.
Correct. On the top side of the tape, there were results at 6 of the loci, or locations, or markers. On the underside of the tape, as far as the locations for the STRs, there was a peak, as Mr. Baez has pointed out, a 17 that was present at the D3 locus.
And how many people did you go through? How many people did you look at to see if they had a 17?
I went through the 5 known samples that were submitted as a part of the case, or the profile that was generated for Caylee Anthony, the known sample for Casey Anthony, the known sample for Cindy Anthony, George Anthony, and Lee Anthony. And then I compared it to the known reference samples that were from the laboratory staff. And there were a total of 5 individuals from which I collected a sample from, and DNA profile was generated for them.
And did you find someone that could not be excluded?
Again, based upon the report language that I utilized, I did not draw any conclusions to the information at that location. Based on my report, it says that that information was inconclusive and was not utilized for comparison purposes.
So if I understand you correctly, it doesn't meet your threshold to either include or exclude anyone.
It was very limited, so I didn't feel that it was suitable for that comparison, to report out a comparison in my report.
Was there another individual that had a 17 at the D3 marker that you looked at?
There was an individual, as a part of their DNA makeup at that particular locus, the D3, they did have one of their alleles was a 17.
Okay, and what did that person have at the D3? What were their?
The DNA makeup at that particular location for that individual was a 16-17.
However, you didn't see any 16 at the D3 local from the duct tape, did you?
This goes beyond what the court allowed my cross to be interrupted for.
I don't believe so. This is clearing up the issue, Judge. This is what I would have done under direct.
You may continue.
There was, what was on the duct tape, there was no 16, correct?
The peak that there was just the 17 that was at the level of detection for a peak.
So, just so the ladies and gentlemen of the jury can understand, this could be 2 things. A person can have 2 alleles, or a person can have 1 peak, like you had described earlier, correct?
Correct. You're either a heterozygote or a homozygote. Heterozygote having 2 peaks, like you referenced, or a homozygote just having the 1 peak.
Okay. And the person that is a lab personnel is a heterozygote, meaning they have 2 peaks.
That is correct.
But all you found was 1 peak.
1 peak that was reported, correct.
Now, because it's so low, you can't make a determination at all as to either way, correct?
That's correct. As I stated, it was inconclusive for reporting purposes.
But what you can definitely say is that there is no 16 at the D3 marker for that peak.
Using the thresholds that we've discussed about from the FBI laboratory, that is correct.
I have no further questions.
Okay, Mr. Ashton, you may continue.
The reality of it is that this peak really means nothing. It's inconclusive. It really shouldn't be taken to mean anything. Isn't that really the reality of this?
And that is the result that I provided in my report, that it was the results for that were inconclusive.
Right. And the reason for that is because at those low thresholds, you can drop out alleles. In other words, you can have someone with a 16, 17, but the 16 is so low it doesn't appear.
That's correct, referring to stochastic effect, where you have alleles that may be there at one amplification, and you may not get the same result at the next amplification because it is such a low level of DNA.
And that's why the scientifically responsible attitude toward this is simply, it's inconclusive, it doesn't mean anything.
That's correct.
But if it meant anything, it's not the DNA of George Anthony, correct?
At that particular location, Mr. Anthony did not have a 17.
All right. Okay. Now,
Mr.
Tell
Ashton? Mr. Ashton, may I ask one question?
sure.
Would that be okay, Judge?
Yeah.
I just want to be clear, the DNA types that we did talk about earlier about the same tape for Caylee Anthony and Casey Anthony, I just wanted to be clear on the types. I think I may have misspoke with
Sure.
the types that were at D3, so I just wanted to be sure the jury was clear on the types that were present, if that would be appropriate.
Right ahead.
Okay. Caylee Anthony at D3 is a 14-15, and Casey Anthony is a 15-19. And I think I had referred to them both being a 14-15, and I apologize for that.
Now, let's see, we've talked about the, Mr. Bias spent a great deal of time asking you about blood. You test for blood on items of evidence for the possibility that blood was shed during some event, correct?
Correct. That's one of the forensic examinations that's performed in the laboratory.
Testified to. She testified that she tests for blood.
Oh,
It's one of the examinations to examine items of evidence for biological fluids, and blood being one of them. I cannot speak to possibly how the nature of the substance would get on the item. I'm just looking for it to detect if there is any biological fluid present.
For instance, if someone is shot, there may be blood spattered or bleeding from a wound, something like that.
That's correct.
Or
Sure.
if someone is stabbed, there can be blood, again, gushing from a wound that might be on a piece of evidence.
Sure. That's
If
correct.
someone is killed in a manner that does not shed blood, the absence of blood doesn't indicate the absence of the crime. Would you agree?
Objection, Judge, calls for speculation and outside this witness's area of expertise.
overruled.
I'm sorry to
Sure.
make you, could you repeat it one more time?
That's okay. I'm just talking about the significance of the lack of blood on a particular crime scene. If a method is used to kill someone that doesn't involve bloodshed, then the absence of blood doesn't really say it didn't happen, correct? I mean,
Correct. I couldn't, yeah, correct. I couldn't speak to whether or not it happened or not.
Okay.
Right.
Now, let's see, we've talked about the items from the trunk. Oh, the tape. Were you involved in any way in the discussions about the order of examination of the tape? In other words, what should come first, second, third, those kind of things?
No, sir.
Okay. It's true, is it not, that you, based upon the history you were given of this tape, would not have expected to find any DNA from the victim on the tape? That's correct, isn't it?
If I may answer without yes or no. The expectation would have been on the sticky side of the tape if it had been, in fact, across the face of the victim. That would be the possible area where I would expect to find DNA, but again, with the information about where the exposure and length of time, I didn't expect that there would possibly, the expectation was neither here nor there. It was a test that was performed, but if there was going to be DNA, the expectation would be that it would be on the underside where cells would be collected on.
But for DNA to survive on an object in a swampy area for 6 months would be unlikely in your experience. Isn't that correct?
Sustained.
Your Honor, I believe we have expert testimony. May I argue
Yeah.
the bench? Because I do.
Yeah. You may proceed.
Let me just ask you, how was the area where the remains in the tape were found described to you?
It was described in an electronic communication as being an area that would have water coming into it in a swampy type area.
All right. Now, what would happen to any DNA on the tape under those conditions in Florida, in the heat, for 6 months?
Well, if water was coming in and receding out and drying and humidity, it is probable that if there were cells contained on there, that the cells could start to degrade over time, and the DNA that would be contained in there would also start to be diminished and to degrade.
Okay, thank you. And would that same answer apply also to things such as the shorts or the other clothing items that you were asked to examine from the same scene?
Yes, sir.
Now, in this case, Mr. Baez asked you about something he called a paternity test. The FBI doesn't actually do paternity testing, does it?
No, sir.
In testing the known samples you were given from Cindy, George, Lee, Casey, is it possible, and eventually from Caylee, correct?
Yes, sir.
And just so we're clear, the sample from Caylee was the marrow from one of her bones. That's what you ultimately tested.
Beyond the scope of direct.
Overruled.
Is that correct?
There were 2 samples that were processed for the identity of Caylee Anthony. One was initially a toothbrush, and then the tibia was submitted, which was ultimately the powder from that tibia was utilized to process and generate a DNA profile.
All right. And Mr. Baez asked you about a quote-unquote paternity test. What you actually did was look at an existing profile of Lee Anthony, the profile you got of Caylee, and make a determination as to whether he could be the father, correct?
Right, I generated the DNA type from Mr. Lee Anthony and using Casey Anthony's DNA type, taking the 2 of their DNA profiles and comparing that to Caylee Anthony to determine if there were alleles present that would suggest those 2 individuals.
And there weren't.
That's correct.
So to summarize all of the testing that we've discussed here, the stain that was in the trunk of the car, all you know is it's not blood.
That's correct.
You can't tell anything other than that.
That's correct. I did not generate a DNA profile either. That's correct.
And the only DNA on anything from the scene is explainable by DNA from lab personnel. Would that be a fair statement?
Misstates the facts and evidence.
Overruled.
From the outdoor crime scene, in addition to identifying Caylee, the only DNA profile that was generated from the outdoor scene was that of a laboratory staff member.
No further questions?
Redirect.
You testified, Ms. Seubert, about decomposition in the trunk and talked about as cells break down, there's no longer an ability to get DNA, correct?
It diminishes over the time period. That's correct.
And that's what I want to ask you about. You can't testify as to at what point during the decompositional phase that you would not be able to get DNA, can you? Except the later stages.
There's many, it's hard yes or no answer, Your Honor.
Answer.
And just explain it away.
Okay.
Go ahead.
So, well, it depends on what exactly, when you talk about obtaining a DNA profile, you're trying to do. Are you attempting to generate a known DNA profile for the identity of that individual, utilizing a bone, utilizing a tooth? Those are the types of body parts that will remain, the skin, the tissue, the blood, and that over time will start to decompose and start to disappear. But the more hardy for lack of a better word, the hardy areas in the body will remain. But as a body decomposes, all of those tissues, cells, and fluids that are contained within us will start to degrade, and the ability to generate DNA from the collection of those types of cells and bodily fluids diminishes.
And that happens at the latter part of decomposition, does it not?
Objection, leading.
Sustained, rephrase the question.
Yes, sir. Does that happen at the latter part of decomposition?
Objection, leading.
Overruled.
When you ask the question at a latter part of decomposition, are we talking, what is the environment for that decomposition that's happening? Is it in a hot environment? Is it a cold environment? Because all of those factors are going to play a part in how the body breaks down.
Right.
And so in order for me to give a scientifically based answer as to where is the period in time that I can no longer generate a result, I can't give you that answer.
You can't say.
I cannot say.
Okay. However, what you can say is that you did not get DNA or blood from the trunk of that car, correct?
That's correct.
And is it your understanding that in the early stages of decomposition, there is blood?
If you think about what's running through our bodies, there's the circulatory system comprised of blood. And so as a body starts to decompose, those fluids are going to start to leak out from the body. So the possibility would exist.
And there's also a possibility that blood would leak onto a carpet of a trunk liner.
Objection, beyond the scope of her expertise.
I think the witness.
Just a second.
Yes, sir.
Ma'am, can you answer that question within the scope of your expertise?
Yes, sir.
Then you be permitted to answer.
Go ahead. You can answer.
Well, within the confinement of a trunk, if a body is placed there and it's slowly going to decompose, all of those fluids are going to start to dissipate into that carpet or the trunk liner if that is contained within the trunk and the body is just placed there and not contained with any type of protective material. It would just be placed there as such.
And if it is contained in a plastic bag and there is a hole in the plastic bag in the front where you tie it up, could it leak out of that area? Is it possible?
Sure, it's possible.
Okay. Now, I think I just have one. The summary that you gave on as to the items recovered at the scene, you could only testify to the contamination aspect of the potential contamination of the lab person on the non-sticky side, correct? Of the duct tape?
Objection, leading.
Sustained, rephrase your question.
When you gave that answer, you were considering what is reportable through your protocols, right?
Objection, leading.
Sustained.
Were you taking, look, let me ask you this way. As you were giving the answer to Mr. Ashton in reference to what you were able to get out of the scene, did you take into consideration your protocols? What your reporting protocols are?
When I gave the answer to Mr. Ashton, I was giving that based upon what I issued in my FBI laboratory report.
And that's based on the protocols that you're allowed to report out?
It's based on the standard operating procedure of the laboratory, correct?
And the 17 allele that you can't make any conclusions on, you did not take that into consideration when you issued your report on that?
Well, as discussed, that information for that portion of the tape, could not provide a conclusion to. It was inconclusive. And so in my answer to Mr. Ashton, I was considering what I issued in my laboratory report, and that was a part of it.
And when you discussed about the elements, the outdoor elements, did you consider the, let me rephrase that. When we were discussing the outside elements and the potential of being able to find DNA, you did say that the expectation, if duct tape were placed around someone's mouth and there was if duct tape was placed around someone's mouth, you would more so expect to find that DNA on that portion than the non-sticky side.
Objection leading.
Sustain.
Would you expect to find more DNA on the sticky side or the non-sticky side?
My expectation would be that if there was DNA recovered, it would be more probable or more likely to be on the sticky side.
Thank you, ma'am.
Just one quick question. When fluids leave the body, they continue to decompose, don't they?
Yes, sir.
So even blood that is spilled on a surface, if it's hot or wet, it'll continue to decompose.
Yes, sir.
Thank you.
May the witness be excused.
Yes.
Thank you, ma'am. You may be excused.